All right, let's try this out.
Jell. And now we bring you our radiant master of ceremonies with warmth in his heart and a cold in his head, Jack Benny.
What are you talking about?
Hello again. This is Jack Benny speaking to you through a Kleenex. So don't get too close to your radios, folks. You know how these colds spread.
All right, Jello, again, this is Ben Hitchcock Cross talking to you today. And you've earned it. You've waited. You've sat patiently through the Novak hearing, and here is the decision. We're going to have a lot of coverage about this decision, meta coverage, background coverage, the ins and outs, what happened on that day in history, and so forth. So we've got that. But right now, we are just going to go to take care of a few things here and try to do a cold reading, basically, of what we've got going on for the decision. So much like the Tate one, there's going to be a series of facts that they're going to have, and then a memorandum decision, sort of an explanation of the decision. So we'll do for that, okay? All right. There's going to be some shade against yours truly, and we'll have to take it as it comes. All right. Bam. Sue Novak, Department of State of Wisconsin, CCI. Okay. The complainant first attempted to file a complaint filed January 15th with the ERD. The complainant's complaint was accepted on the 25th of January. For purposes of statute limitations period, the division uses the first date of the complainant attempted to file a complaint. Okay. If the division uses the first date that the complainant attempted to file a complaint, the complainant's complaint alleges that the respondent violated the WIFA by discriminating against the complainant in terms of conditions of employment and by terminating the complainant's employment because of sex, an initial determination issued on November 9th of 2021. An investigator for the division found that there was probable cause to believe that the respondent violated the WIFA as alleged, and the complaint was certified to hearing and to the Hearing and Mediation Bureau for a hearing on the merits of the complainant's complaint. The matter came on for a hearing before the administrative law judge Alice DeLaO on March 29th, 30th, and 31st, and April 25th, 27th, and 28th of 2023 by WebEx, a computer software program. The complainant appeared in person by her attorney, Ben Hitchcock Cross. The respondent appeared by the respondent's attorney, Eric Mullenbach, an in-house counsel for the respondent. The record in this matter closed at the end of the hearing on April 28th of 2023. At the conclusion of the hearing in this matter, the parties were told that initial briefs would be due from both parties on June 6th. The reply briefs were due on June 27th. Due to a delay in a provisioning of hearing recordings, the administrative law judge extended the briefing schedules sent to the parties on May 12th of 2023. The administrative law judge informed the parties that the new briefing schedule would be that both parties had the initial briefs on June 20th and both parties would be able to file reply briefs by June 11th. On June 5th, the complainant's attorney found the most briefing schedule be extended to some unknown date when the complainant attorney had an opportunity to obtain all of the cases from the Labor Industry Review Commission that are not publicly available on the LERC website. So, for example, the judge had cited cases that weren't available on the website, and there was case law cited by other cases in that website that were not available to the public. So we had asked LERC for those cases, and they refused to give it to us at that time. So we made a motion saying postpone all briefing. On June 6th, the administrative law judge denied the complainant's motion to extend the briefing schedule indefinitely. The administrative law judge determined that the complainant was aware from the date of filing her complaint that the case involved the issue of constructive discharge. The complainant's attorney was now stating that the complainant's attorney was not prepared more than 2 years later in the summer of 2023 to write a brief on the issue of constructive discharge to support the complainant's case. The administrative law judge noted that instead of asking LERC for the two specific cases that the complainant wanted on constructive discharge that were not in LERC's website, the complainant asked the LERC to produce the thousands of cases that the LERC had issued on all topics since 1971, so the complainant could write a brief on behalf of the complainant in this matter. The administrative law judge would not grant the complainant additional briefing time since the complainant had sufficient time to be prepared to write a brief with all relevant case law on the issue of constructive discharge. Okay. That does assume there that all issues on the issue of constructive discharge were known to the complainant as of the moment that she filed the complaint and not as of the final date of the hearing, just for example. That's a pretty big assumption there. I don't see any fact in there that makes that out, but she does assume that I could have, this is a common device there, which they say, you could have done X, and so because you did Y, but you could have done X, therefore you can't, you lose. And it's almost always the case that somebody could have done X, just for example. Okay. The complainant filed an initial brief on July 6th, even though initial briefs were not due until July 20th. The complainant filed a supplemental initial brief on the 20th. The respondent filed an initial brief on June 20th. Reply briefs were due on July 11th. The respondent filed a reply brief. The complainant did not file a reply brief. All that's true. We also, by the way, filed a motion to have the judge remove herself from the case because of bias. That happened in there. I don't see. That will be mentioned later on, but that's not mentioned there. So just for the record here, we can all be clear. That's absolutely true that in between that period, there was a motion filed to have this judge remove herself on that issue. So that's how that went. Okay. So let's start going, and I think we'll go a couple pages down in findings of fact for this video and then continue later going from there. Based on the evidence received at the hearing in this matter, the administrative judge makes the following findings of fact. 1, the DOC is an employer. The head of the DOC is a cabinet secretary appointed by the governor of the state of Wisconsin. Hey! All right. Sue Novak is a female, beginning work the Department of Corrections in '89 as a correctional officer. She would be earning about $103,000 as a warden. I think principals make a lot more than that. That's astonishing to me. Astonishing to me, but okay. Career Executive Program was established. Mobility of the career executive employees and agencies. I don't know how that's relevant. State government for the most advantaged use of managerial and administrative skills. Okay. Keep that in mind for future reference. Thank you, Judge. As the warden at CCI, Novak was ultimate authority located at CCI. Novak was expected to oversee and direct all functions of the CCI, including overseeing the staff, inmates, CCI activities, and facility infrastructure with the assistance of her direct reports. Well, but that's just not true. I mean, in no case do we... Mac DeFessahaya doesn't say that's true. Kevin Carr doesn't say that's true. Jim Swatcher doesn't say that's true. Novak doesn't say that's true. I mean, there's a policy that says that, but everybody says that that's not what happens. Wow. Okay. As the warden at CCI, Novak was the appointing authority responsible for hiring employees at CCI and deciding if disciplinary investigations of CCI employees should occur, and to work within DOC policies to impose discipline, including terminating CCI employees when warranted. Well, Novak says that's false. Swatcher says that's false. Fessahaya says that's false. The Internal Affairs investigator says that's false, because only people can be disciplined who are investigated, and people can only be investigated who are authorized to be investigated. And we all know where the authority comes from that. Mac DeFessahaya says that she didn't feel authorized to investigate any discipline, do anybody higher than a officer. And the warden is a totally different scale below her. That's not supported by the facts, the evidence, we'll put it like that. Terminating, the fact we've had it clear that a warden can't terminate. Okay. In making decisions to discipline and terminate employees at CCI, DOC rules require the warden to work with human resource personnel and other officials. As the warden at CCI, Novak was responsible for providing input to DOC management about the budgetary needs at CCI for its staff, programs, and facilities. Okay. It also says that Novak was responsible for providing input to DOC management about budgetary needs at CCI for its staff, programs, and facilities. Well, that's... it was responsible for providing input. It doesn't really mean anything. Soon after Novak became warden at CCI, Novak was informed that the stun fence at CCI, which was supposed to help prevent escapes, had been installed incorrectly when it was erected in 1986. Specifically, the stun fence was supposed to be the first fence that an escaping prisoner would encounter. Instead, the stun fence was the second fence that an inmate would encounter if trying to escape. Novak did not have the authority or the budget as a warden to fix the stun fence. However, Novak could have alerted the DOC management that the fence was installed incorrectly and asked the DOC management request funds to install the stun fence correctly to try to prevent future escapes from CCI during the budgeting process. Novak did not alert the DOC management at any time that the stun fence at CCI was correctly installed. So there's two things let's put about that. She says that the reason that she didn't do that is because she assumed they already knew. We had evidence that they already knew from Carr, from Fesahaya, from Fuchs and others about the after action report. Oh, here's why. On January 7th of 2019, there was a change in administration at DOC when a newly elected governor of the state of Wisconsin appointed a new DOC secretary to be part of the governor's cabinet. The governor appointed Kevin Carr, a male, to be the new DO secretary to be in charge of the DOC and oversee the DOC's divisions. Generally, the most visible job of the DOC is to operate the correctional facilities, prisons in the state of Wisconsin. Okay, so we're gonna see what's coming. Let's assume what's coming from that is she should have awarded everybody, but when he gets in place, it's a clean slate. He doesn't know anything that's going on prior, and the DOC is everything's on Warden Novak and not on the Department of Corrections. After Carr became the DOC secretary, Carr appointed Magda Fesahaya, a female, to be the Division of Adult Institutions administrator. As the DAI administrator, Fesahaya reported directly to Secretary Carr. As the DAI administrator, Fesahaya was responsible for overseeing the 36 prisons in Wisconsin and the personnel who ran the prisons. Fesahaya was the appointing authority for all the wardens that operated the prisons in Wisconsin. Carr and Fesahaya both worked at offices in Madison. So, again, the evidence is that she's the appointing authority, but from her own mouth and from Jim Schwager, she has no authority to do anything other than to investigate an officer. Everything else has to be done in consultation with Secretary Carr. She didn't need to be told that. That's just how things were done. After becoming the DOC secretary, Carr decided to create an Office of Internal Affairs to investigate possible employee misconduct and identify any possible rule violations after investigating the alleged misconduct. As if that had never happened before. Secretary Carr hired Christy Preston, a female, to be in charge of the new Office of Internal Affairs. The Office of Internal Affairs began operating at DOC in December of 2019. She doesn't say that Christy Preston had no experience in that job whatsoever. Just for example, just pointing that out there. Hey. The Office of Internal Affairs investigates possible misconduct to find facts and to identify possible rule violations. When ordered to do so by Kevin Carr. Once the Internal Affairs investigation is complete, the investigation materials gathered by Internal Affairs investigators forward to the appointing authority and to Central DOA Office human resource employees who handle personnel matters for the DOC. Internal Affairs does not determine if an employee is violating work rules, but Internal Affairs will identify possible work rule violations based on the investigation. Internal Affairs plays no role in deciding the discipline that an employee may face if the employee is determined to have committed one or more work rule violations. The DOC has a progressive discipline system that allows skipping lower levels of discipline under certain conditions. All right. From sometime in 2018 onwards, the human resource employee who handled personnel matters at the DOC did not report to the DOC management. In 2018, the human resource employee who had reported to DOC management were transferred to a central human resource staff model. And that human resource personnel reported directly to the Department of Administration. Great. The new internal affairs model, if the appointing authority and the human resources staff following DOC rule decides that one or more work rule violations appear to have occurred, the appointing authority will notify the investigation subject of the proposed rule violations that were identified after the investigation and tell the investigation subject that the investigation subject may present evidence to rebut the proposed rule violations and to present any other relevant evidence at a predisciplinary hearing. Now, Jim Swatchett says that's not true. Magdafesta Haya says that's not true. Again, she says the only thing that she felt comfortable doing on her own initiative was investigating low-level staff officers, and that's it. All right. The Internal Affairs investigation will then conduct in a predisciplinary hearing for the subject of investigation to present evidence regarding why the subject should not be charged with the rule violations. No, it's to find out if they should be disciplined, why you shouldn't be disciplined. It's not a predisciplinary hearing. It's not to find out why you shouldn't be charged with the rule violation. You have been charged with the rule violation. They issue a predisciplinary hearing. You have a hearing to say, I dispute these charges for these reasons. The Internal Affairs investigators then forward the information from the predisciplinary hearing to the appointing authority for the investigation subject and the Central Human Services Resource staff for review in accordance with DOC rules. Not accurate. Prior to the creation of the Office of Internal Affairs, DOC correctional institutions investigated themselves. With the creation of Office of Internal Affairs, an independent entity was created to investigate possible misconduct by DOC employees, separate from the correctional institutions where the employees worked. That's just not the case. With the creation of the Central Human Resources staff of the DOA, the human resource function gained independence from DOC management. That's a stunning statement. Stunning. If anything, it's controlled at a higher level. And there's also plenty of testimony by Jim Swatchett, among others, that they and Fuchs, that they had been called in from other areas that they had worked to investigate and to assist specific prisons by upper management. So not by nothing in that paragraph, based on my review of the evidence, I could say is true. So we're pushing a few minutes here. I'm going to get on with the holidays, but here we are. Stick with us. We'll keep you informed.